Hello and welcome to Navigating Utah's River Access, a three-part webinar focused on stream access in Utah. Today's webinar is titled The Past, Present, and Future of Stream Access in Utah. I am Chase Lamborn, the Assistant Director of the Institute of Outdoor Recreation and Tourism at Utah State University, and I will be facilitating today's webinar. Just to provide some background on the Institute, we are formally recognized by the Utah State Legislature, and we provide research and technical support to help communities, governmental, and non-governmental agencies plan and manage outdoor recreation and tourism in Utah and beyond. And we are incredibly excited to be hosting this webinar series, and we hope the information shared here will be valuable in helping people understand the rights and responsibilities we all have regarding water access in the state of Utah. But before we get started today, I just want to thank the Office of Property Rights Ombudsman and the Land Use and Eminent Domain Advisory Board for funding this webinar, along with some educational videos and a workbook that we will be releasing in June. And another thing that I want to cover before we get started is just this disclaimer that the purpose of this webinar is to provide practical and educational information about stream access in Utah for both private landowners and the recreating public. And efforts have been made to ensure the information is consistent with Utah's current stream access framework. However, it is not legal advice. Please consult applicable laws, agency landowners, and or legal counsel when specific questions or disputes arise. And so, as I just mentioned, this webinar consists of three parts. Today, which is the first webinar, we will be discussing the history of stream access law, the current law governing stream access in Utah, and how things may change moving forward. The second webinar, which will be held on May 26 at 11 a.m., is titled Utah's Stream Access, Rights, Responsibilities, and Enforcement. And the goal of this second webinar is to provide some practical information to landowners and the recreating public. We have also invited law enforcement to describe some of the common conflicts they see and respond to, along with some tips to help reduce these types of incidents. And the third and final webinar will be held on June 2nd at 11 a.m. and it is titled Working Solutions in the Current Framework. And the goal of this webinar is to showcase ways private landowners and the public are working together to develop opportunities that are mutually beneficial for both parties. And so today we are joined by two very special guests who have extensive experience with stream access in Utah. Mr. Randy Parker he has served as the CEO of the Utah Farm Bureau and has been an advocate for property rights in Utah. He has also attended navigable for title cases before the Utah Supreme Court and the Supreme Court of the United States, and he contributed to the development and passage of Utah's Public Waters Access Act. And then Mr. Cullen Battle is a retired attorney who has written and spoken widely on stream access in Utah and elsewhere in the West. And in 2017, he also represented the Utah Stream Access Coalition in a lawsuit that established navigability on a section of the Upper Weaver River. Now, over the course of planning this webinar, it has been a great pleasure of mine to get to know these two gentlemen. And although they have spent their time on opposing sides of the Utah stream access debate, both have shown to be very knowledgeable, but also incredibly sincere. And I trust everyone attending will learn a great deal from them today. And so I have already discussed this with our presenters, but I just wanted to let everyone know that the purpose of this webinar series is not to openly debate what should or should not be with regards to stream access in Utah. The primary purpose of this webinar series is just really to share what is and help us understand that better. So with that, Randy will walk us through, as he likes to describe, the roller coaster history of stream access in Utah, which will cover the state and federal laws that have affected access in Utah and private property. From there, Cullen will provide an overview of the Public Waters Access Act and provide some information about navigability at both the state and federal levels. After these two presentations, I have a couple questions for our presenters, and there will also be a short question and answer session. So if you have questions for these two, please put them in the chat and our team will ask them at the end. So, and I also wanted to mention that Randy has a one pager that if you would like to, that we just posted in the chat, if you would like access to that, it is there so you can follow along with him and then have that after the presentation. So without further ado, I will turn the time over to Mr. Parker. The time is yours.
Thank you, Dr. Lamborn, for the great introduction. I am a proud Aggie and appreciate the opportunity to share some thoughts today and participate in this important webinar. As I think about the future of the beautiful state of Utah, the fact that 65% of our state is owned and controlled by the federal government makes me think back to John Adams' observation, and it's even more relevant today. Adams, second president of the United States and a framer of the U.S. Constitution in 1790, declared, "Property must be secured or liberty cannot exist." Today, I'll share some of Utah's legislative history related to stream access and the Public Waters Access Act, legal underpinnings, and protection of private property rights. Next, I'll provide some history and definitions of navigable for title and navigable in fact. My presentation today will come from a private property advocate standpoint. I come from a ranching background and earned my BS degree in ag business and MS degree in ag economics from Utah State University. While serving as CEO of the Utah Farm Bureau, I was honored to be invited to testify 5 times before the United States Congress House Committee on Natural Resources on states' rights, water rights, and private property rights. Utah has a long history of honoring and protecting property rights. The fact is embedded in Utah's Constitution. Article 1, Section 22 states, private property shall not be taken or damaged for public use without just compensation. As the 21st century started in June of 2000, Kevin and Jody Conitzer were cited by the Morgan County Sheriff for criminal trespass. They were fishing on the Weber River and refused to exit the privately owned stream bed. The Morgan County Justice Court found the Conitzers guilty of criminal trespass. This action ultimately set in motion a quarter-century roller coaster ride for both landowners and recreation interests. In 2008, Conitzer was appealed to the Utah Supreme Court. In the court's written opinion, they referred to Wyoming Supreme Court decision Day versus Armstrong, 1961. Wyoming determined the public's easement was limited to floating on the state's waters that flow over privately owned stream beds. Additionally, they added important insight from their own 1982 JJMP decision. The Utah Supreme Court found the right to private property is one of the oldest and most cherished rights and is protected against unauthorized invasion by the state. In reversing Conitzer, the court ignored their own admonition from JJMP to protect private property, as well as ignoring Day, the float-only finding that they cited. This raises questions about the court's decision. In the Supreme Court's written opinion, paragraph 14, they stated, "Instead, we make our own rule that the public has the right to float, leisure craft, hunt, fish, and participate in any lawful activity when utilizing the water." They granted the so-called Conitzer easement. My friend, State Representative Kay McKiff, who served as a Sevier County attorney and 6th District Court judge, saw this action by the Utah Supreme Court as judicial overreach and an invitation to the legislature. To address this overreach, McKiff drafted HB 141, the Public Waters Access Act, which was overwhelmingly passed by the legislature and signed into law by Governor Herbert in 2010. The roller coaster ride was officially underway. Current law, Utah Code 73-29-202, specifically allows only incidental touching of privately owned stream beds. McKiff's Public Waters Access Act revoked the Conitzer easement. In addition, in 2023, the legislature and governor added private stream beds and banks to Utah's criminal trespass code 76-6-206. Utah state law is clear. Walking on privately owned stream beds and banks is breaking the law, and law enforcement across the state in every county is obligated to enforce. Private property and title. As we are celebrating the 250th year of America's independence, it's important to understand our founding fathers who lived under the heavy hand of the British Crown. They believe property is meaningless if settled expectations of ownership may be dashed at the whim of any branch of government. Ownership of property, as with every other valued right in America, depends greatly on judicial decisions. But the foundation of our right to property is fundamental and guaranteed in our Bill of Rights. The founders included the Takings Clause in the Fifth Amendment to our Constitution as a protection. It expressly forbids federal, state, and local governments from taking property without just compensation. Due process clauses in the Fifth and 14th Amendments to the Constitution assure life, liberty, and property cannot be taken by government without due process of law. The highest court in the land, the U.S. Supreme Court, in American Land Company versus Zeiss in 1911, underpinned the importance of property rights. SCOTUS declared, "It is the responsibility of governments to ensure certainty of title because the general welfare of society is at stake." That's an important thing to remember, that government must ensure certainty of title. Utah's 6th District Court in Alvey Development Corporation versus McElfrain in 2002 recognized the importance of certainty of title. The court found in Utah there is an important interest for property owners to possess unencumbered titles because public policy favors certainty of title to real property. Defining navigable for title and navigable in fact. Some argue, including a few county attorneys, that somehow this is unsettled as it relates to navigability on certain Utah streams. Some have even chosen not to enforce Utah laws established to protect privately owned stream beds and banks from trespass. The standards for government to claim navigability for title that adversely affects someone's right to property are well defined. Business growth as a result of the Commerce Clause moved beyond the tidal waters to inland rivers. A standard of navigability began to take shape in the nation's courts. In the Daniel Ball, 1870, the U.S. Supreme Court established the navigable in fact standard for inland rivers. The rivers are navigable in fact when they are used or susceptible of being used in their ordinary condition as highways of commerce over which trade and travel are or may be conducted in customary modes of trade and travel on water. Now, please note that it says trade and travel, not trade or travel. United States versus Rio Grande Dam and Irrigation in 1899 provided guidance, important guidance, on a river of minor commercial value not qualifying as navigable in fact. The mere fact that logs, poles, and rafts are floated down a stream occasionally and in times of high water does not make it a navigable river. This navigable in fact standard is an important consideration for Utah rivers and streams that have high water during spring snowmelt, then tend to run intermittently thereafter. United States versus Holt State Bank, 1926, the U.S. Supreme Court defined that there is one standard, navigability, when asserted as a basis of a right under the U.S. Constitution, is necessarily a question of federal law to be determined according to the general rule recognized and applied in the federal courts. Because of the important federal, state, and private interests at stake, having one test for navigability in fact is critical. United States versus Utah, 1931. The stream must have been used for trade and travel in its ordinary and natural condition at the time of statehood. In 2012, the United States Supreme Court heard the PPL Montana versus Montana navigability case. The state had claimed ownership of 3 major rivers. Then they sent PPL Montana a rent bill for $41 million for plants generating hydroelectric on the state's rivers. The Utah Farm Bureau submitted an amicus brief on behalf of the petitioner. As CEO of the Utah Farm Bureau, I had the honor of attending oral arguments. The court, in a unanimous 9-0 decision, said it is well-settled law and is based on a segment-by-segment determination to establish navigability for title in customary modes of travel at the time of statehood. Now, here's a quick recap. Number one, navigability in fact requires use or susceptible of use for both trade and travel. Number two, where logs, poles, and rafts are floated occasionally during high water does not make it a navigable river. Number three, navigability is a question of federal law to be recognized and applied in the federal courts. So there is only one test for navigability in fact. Usefulness, number four, usefulness for trade and travel in a stream's ordinary and natural condition. Number five, navigability is based on a segment-by-segment determination in customary modes of travel at the time of statehood. And number six, navigability for title is not unsettled unless a river segment in question is being reviewed by the courts. Now to Utah's legal roller coaster ride. In 2000, the Conatzers were found guilty of trespass while fishing on the Lower Weber. On appeal in 2008, the Supreme Court reverses, then establishes their own rule, granting the right to recreate on privately owned stream beds. Responding to the Utah Supreme Court making public policy, Representative McKiff in 2010 returned policy making to the Utah legislature. The Public Waters Access Act followed JJMP and Day precedents recognizing the public's right to float on the state's waters and providing incidental touching for public safety. 4th District Court Judge Derek Pullen in 2015 in Utah Stream Access Coalition versus Victory Ranch invalidated core provisions of the Public Waters Access Act, saying it violates Article 20 of the Utah Constitution. He determined there is a public easement to use rivers and streams held in trust for the people of Utah, ultimately with statewide private property implications. The Utah Supreme Court in Utah Stream Access Coalition versus Orange Street Development in 2017 on the Upper Weber River determined log drives on a 1 mile segment establish navigability for title as set forth in the equal footing doctrine. It's interesting that the court did not take a position on who holds the title. From that 1 mile segment, the court determined to be navigable. Utah DNR then expanded the recreational access to 40 miles on the Upper Weber River from Holiday Park downstream to Echo Reservoir. On remand in 2021, the Utah Supreme Court asked District Court Judge Pullen, were there actual easements at statehood? In his reversal, Judge Pullen states, the public has no right to walk on or touch the bottoms of streams crossing private property because there was no formal easements to non-navigable streams in Utah. As an interesting side note, in 2022, the legislature considered House Bill 129, navigable waters determination. It would have allowed the Department of Natural Resources to make administrative determinations on navigability. I've got a couple of questions. Would this bill have compromised the state's obligation to ensure certainty of title, or the high standard that one test for navigability is necessarily a question of federal law? The bill did fail. In 2023, the Utah Stream Access Coalition versus Victory Ranch, the Utah Supreme Court weighed 19th century pioneer use of Utah streams in a present day easement. The court found no constitutional protection for the public's right to touch privately owned stream beds underlying the state's waters. The court concluded that further policy considerations are better directed to the legislature. So does this roller coaster ride and uncertainty affect people? My presentation has been focused on history, courts, and law, but it's important to bring into this discussion the impact this roller coaster ride has had on property owners and their families. After serving our country in the United States Army for more than a decade, a man with a young family took his savings and made a down payment on a piece of property with a river running through it. A premium was paid for the riverfront property, and in the 1980s, they paid more than 10% interest on their loan. As property increased in value, of course, the family paid higher associated property taxes to the state. That purchase was made more than 40 years ago. After a lot of blood, sweat, and tears, the family built a business that they are very proud of. Sadly, the Utah Stream Access roller coaster ride has hit this family personally and financially. In 2010, the passage of the Public Waters Access Act gave them control of the river to maximize their investment. That, however, was short-lived. Judge Cullen in 2015, disregarding certainty of title, allowing walking on privately owned stream beds, hurt the family, their investment, and their business. After 6 long years in 2021, Judge Cullen reversed, which I'm sure was a disappointment to many. When Cullen reversed, some of those adversely affected were unhappy and have let their feelings be known with angry words, gestures, and even some threatening messages left on the family's property. Today, like Orange Street and Victory Ranch, that family finds themselves in court. Did Utah state government ignore its obligation of ensuring certainty of title when it sued the family, claiming their river property is navigable? For the pending court battle, the family has been compelled to hire a team of legal experts. To cover the growing expense, they have been forced to sell off some of their land holdings. The State of Utah Division of Forestry, Fire, and State Lands legal expenses will be covered by Utah taxpayers, including taxes paid by that family. Looking back more than 130 years to 1896 and statehood to determine whether or not the stream meets the high legal standard and is navigable in fact seems daunting. The affected family will never be the same. The outcome will have major impacts on 4 generations of a family business. Their expectations of property ownership and their constitutional right to life, liberty, and the pursuit of happiness have been dealt a major blow. Thank you.
Thank you so much for that historical perspective, Mr. Parker, and for how that has affected this current family. Next, we will be hearing from Mr. Cullen Battle, who has provided an overview of, as Randy mentioned, the current law guiding all of this in Utah, which is the Public Waters Access Act. So without further ado, Mr. Battle, the time is yours.
Thanks, Chase. I'm going to start out by going through the Public Waters Access Act, which was passed in 2010, and since then has governed what the public can do on non-navigable streams flowing across private lands that are posted, fenced, or cultivated. We're talking about essentially all waters in the state except 2 categories: navigable waters and waters on public lands. The streams that are covered by the act range from portions of our largest rivers, such as the non-navigable private land sections on the Green and Colorado rivers, to all of the small creeks and streams that run through private land. In total, this is approximately 7,200 miles of public waters that before 2010 were fully open to the public and are now subject to the restrictions of the Public Waters Access Act. If we could go to the next slide. The way the act works is that it essentially prohibits any public use of these waters without landowner permission, except for what is shown here on this slide. Um, the public is limited to floating on water that has sufficient width, depth, and flow to allow the free passage of a chosen vehicle. Those are the words that are used in the statute. And this means you can float through private property on any river or stream that can float a drift boat, a raft, a kayak, or even an inner tube. You can incidentally touch the stream bed of that stream in order to maintain safe passage. Um, you can portage around uh, dangerous obstructions, but you have to take the shortest route possible that's closest to the water. This includes fences and other man-made obstructions, as well as rapids or other natural hazards and obstructions. Um, you're allowed to fish while floating, uh, and but there's one exception to this overall right to float, and that is that it does not exist on impounded wetlands. Basically, it exists on rivers, streams, and natural lakes. Um, if we go to the next slide, this shows you what you cannot do. You cannot wade in the river. You cannot anchor a boat anywhere in the river. Um, you cannot engage in any other non-incidental touching of the stream bed or the banks of the river. And that means you cannot leave the river and walk along the banks except for the limited case of portaging around a dangerous obstacle. Uh, you cannot hunt. You cannot stop on private property. And there's some uh, there is some uncertainty about what that last point means. The way the statute reads, a person exercising the right that this section recognizes, i.e., the right to float, may not stop on private property. Now, some landowners claim that that means you're not allowed, if you're in a kayak or a raft, to pull over and stop your downward progress by resting in an eddy, floating on the water, not touching the bed, not touching the banks. You've got to keep on moving through. I disagree with that interpretation. I don't think it makes sense given the way the statute's written, but that is one area of uncertainty that there is a disagreement about. One thing that there isn't a disagreement about is that under the Public Waters Access Act, violation of these rules constitutes a criminal trespass. Um, that's a Class B misdemeanor with penalties that include jail time up to 6 months and fines up to $1,000. Um, Other provisions of the Public Waters Access Act that Chase asked me to cover, uh, fencing. The act says that a landowner is allowed to place a fence or other obstruction across the water if it does not create an unreasonably dangerous condition to members of the public using the water. Um, so there is some protection for boaters. Um, uh, and there would be liability on the part of a landowner who violated this rule and somebody got hurt uh, by a fence that was unreasonably dangerous to people running the river. Um, uh, Otherwise, the statute uh, specifically provides, as I indicated earlier, that it does not limit access to navigable waters or waters on public land. Um, and if we go to slide number, jump ahead 2 slides to slide 6, public prescriptive right of access, quiet title. Chase also asked me to cover this subject. The statute recognizes a right where members of the public uh, have used private property openly, or have used the waters on private property openly, continuously, without permission and without interruption for at least 10 consecutive years after September 22nd, 1982. Um, uh, the existence and scope of this public right is determined by the courts in a quiet title lawsuit that can be filed by a member of the public, by the Division of Wildlife Resources, or by a landowner seeking to declare that no such right exists. Um, this provision sounds good for the public, but it doesn't have any real practical value, and it has not been used once in the 16 years since the Public Waters Access Act went into effect. Um, it, I'm not going to go into great detail about why that is, but essentially, it's because it's very, very difficult to find witnesses and to prove 10 years of continuous public use on any specific piece of property. And it would require an adjudication of separately for every landowner along the stream versus the kind of adjudication that can occur on an entire section of the river. So nobody's used this yet. It's possible that it could be used in a specific situation, but I'm not aware of any such situation that has arisen. So that's the Utah Public Waters Access Act in a nutshell. Um, I've given you what is sort of the distilled version, the takeaway, the bottom line, so to speak. If you want to read it yourself, I'm not sure I recommend it. It's pretty hard to read. It's pretty confusing in the way that it's written. But you could either Google Utah Public Waters Access Act, and it will come up, or you can look to the Utah Code section 73-29-101. That's where it starts. I'm going to shift now to navigability. Randy talked about that some. I'm going to fill in some additional information. But I wanted to say that navigability is incredibly important to the public today because it's the only avenue remaining for the public to obtain full access to rivers that flow through private land. Um, there is federal law and there is state law that applies on this subject. And just so you understand where this all comes from, I'm going to go through some sort of some basic foundational principles. Um, the first one being, if we go to the next slide, under federal law, um, upon entering the Union, every state gains title to the beds of all waters within its borders that are then navigable. Um, in other words, the beds of navigable rivers are state public lands. We refer to those lands as sovereign lands. They are They're lands that the state obtains at statehood from the federal government, which owned the land prior to statehood. And so essentially, the beds of navigable rivers are public lands, and there can be no trespass, and the Public Waters Access Act does not apply. And Randy talked about the Daniel Ball case, but I've got it here so that you can read along with me because this tells you what rivers are navigable. They're the ones that are used or susceptible of being used in their ordinary condition as highways of commerce over which trade and travel are or may be conducted in the customary modes of travel and trade on the water. That's the magic language. Um, State law comes into play here. Um, Under Article 22 of our state constitution, all lands that the state has been granted, all lands that have been granted to the state by Congress are declared to be the public lands of the state and shall be held in trust for the people for the respective purposes for which they have been granted. And under our Supreme Court decisions over the years and under current state law, this public trust that's guaranteed under our Constitution includes the beds of those navigable waters that were granted to the state at statehood. And this trust protects commerce, navigation, and fishing. Now, there was no list presented to Utah at statehood stating which rivers were navigable and therefore belonged to the state and which rivers were not. It was essentially a big to be determined item that we have been, for the last 200 years, essentially been finding out piece by piece, river by river, case by case, what streams are navigable and what streams are not. Now, another big question is who gets to make this determination of navigability? Who gets to say whether a river is navigable or not, and what the public rights are on navigable rivers? Uh, the answer is that the courts do that, not the legislature, not the governor. The legislature can make rules for non-navigable streams, and as it has done with the Public Waters Access Act, but it cannot do that with navigable waters. And there are two reasons why not. First of all, determining navigability, determining whether a river meets the highway of commerce test that we have described, requires an adjudication of historical facts, and only courts can do that. Legislatures are not set up and don't have the ability to adjudicate a case. And secondly, under that public trust provision of Article 20 of our Constitution, um, it limits it limits the power of the other branches of government in dealing with these lands, and it falls to the judicial branch to interpret and enforce the provisions of that trust because it is a constitutionally guaranteed trust. Now, there are probably a lot of members of the legislature that would disagree with me on this, but what I'm telling you is very well settled law. The courts in Utah, both state and federal, decide the questions of navigability. Um, it is the source of law is federal, but a state court as well as a federal court can and they have done in several cases applied federal law to determine whether a river or lake in Utah is navigable or not. To date, I'm gonna give you the list of the rivers that have been determined judicially to be navigable. portions of the Green River, portions of the Colorado River, um, the lower Bear River, the Great Salt Lake, Utah Lake, and most recently, the upper Weber River. And presently, the Provo River is under adjudication. Um, in the cases of the Bear and the Weber and the Provo, the evidence of navigability consists primarily of statehood era log drives, mostly railroad ties, but also logs floated to sawmills, cordwood, and mining timbers. This this is the evidence that we presented in the Weber River case that Randy mentioned. Um, this is the same evidence that exists on the Provo River um, that is under adjudication now. And this is the evidence that our Utah Supreme Court held established the navigability of the Weber River. Now, the adjudication in that case concerned a set of properties on a 1 mile stretch of the upper Weber. But the evidence that was used to determine that that particular stretch was navigable consisted of log drives that started at the headwaters of the river and went all the way down through those particular properties and on to the railroad connection at the mouth of Echo Canyon. And that is why the DNR has declared, in the wake of the Supreme Court decision on the Weber case, that the entire section of the river is uh, is navigable and therefore is no longer subject to the restrictions of the Public Waters Access Act. Looks like I'm pretty much out of time, so why don't I'll end it here and we can move on to questions.
Yeah, thank you so much for that overview, Cullen. Yeah, if both Randy and Cullen, you can leave your video on, but if Randy wants to jump on, I have a couple questions for you too, and then we can jump into the broader questions for from attendees. So, kind of coming from what you were discussing here, Cullen, when someone wades into this stream access legal debate that you were providing an overview, and Randy also provided a lot of history on how this has gone back and forth. Some commonly used and very consequential terms are equal footing doctrine, public trust doctrine, and navigability, which you just outlined. But for equal footing doctrine, public trust doctrine, and navigability, how do or what do all these terms mean, and how do they interact with each other with regards to stream access in Utah?
I'll start with equal footing doctrine. That's a sort of a fascinating historical concept that underpins the rule that I described earlier, that where the state automatically gets title to the beds of all of its navigable rivers at statehood when it becomes a state. And the title passes from the federal government to the state upon the creation of the state. Um, and people ask, well, who said that? Where does that appear in the Constitution? Is there a federal statute that says that? And the answer is no, there's not. There's a thing, but there is something that's called the equal footing doctrine. And that does appear in our Constitution. And it says that every state that was created in our country after the original 13 colonies formed the United States, every new state comes in with the same sovereign rights and powers as the original states. We don't have first-class states. We don't have second-class states. All states are on an equal footing, if you will. That's the equal footing doctrine. Now, how does that relate to navigable waters? Well, the original 13 colonies used to be part of England. And in England, the crown held the title to all of the navigable waters of England. And when the 13 colonies became the original states of the United States, they substituted themselves and specifically the people of the state for the crown in England. And so that's why those states, when they became states, had title to the navigable waters within their borders. And any new state entering the Union got the same. Um, and that is that's the source and that's the relevance, if you will, of the equal footing doctrine. Now, public trust doctrine kind of flows from that same principle. Public trust doctrine um, deals with the fact that these lands are sort of held, the beds of navigable waters are held for a specific purpose and held in trust for the public to uh, protect those purposes, navigation, commerce, fishing. And that was the case in England. The crown held the lands, but the public was allowed to use them as a right. The general public were given rights for commerce, navigation, and fishing over these crown lands, and so the states inherited that same role, and the public, but they held the title of these beds in trust for the purpose of protecting the rights, public rights, navigation, commerce, and fishing, and they um, could not be treated like other state lands, bought, sold, etc. They had to be held for those specific purposes. And that's why navigability is the sort of the last stronghold for the public with regard to the streams that flow across private land.
Okay.
And I think I've probably answered the question already about what does navigability mean. Randy talked about it. I filled in some more. I hope I've given everybody a reasonable summary of this very complicated area of the law. I mean, it's taken me so long to get on top of this. I mean, it's been like a lifetime almost to try to figure all this out. Uh, but it does sort of boil down to some sort of common basic principles, and I've tried to outline those.
So essentially, what you're saying is that every state was added to the union, it equals or enters the union on equal footing.
Mhm.
And then if the waters within that state are deemed navigable, then the public trust doctrine kicks in, and then the public has open access to
And
those.
it's the same in every state.
Mhm.
This Randy touched on that in his presentation. We don't have we don't have different navigable waters in Utah, a different test for navigable waters, or at least the title to navigable stream beds is the same in Utah as it is in every other state in the country. Now, our courts might interpret it, might read the question of what constitutes a highway of commerce. Every court has got to make a determination of what does that mean and do the facts of the case meet that definition or not.
Mhm.
So that you can get widely varied interpretations and outcomes from one state to another, but the basic test that they're applying is the same.
Okay. Thank you so much for that, Colin.
Yeah.
And then kind of working off of that, Randy, so the Public Waters Access Act is currently the law of the land in Utah. But within its structure and where we are now, and we've kind of already been touching on this, but as we move forward, how may stream access change? For example, are there, like you already mentioned, there's one pending cases, but are there any, is that, or any other situations that may affect stream access in Utah that you're aware of?
Well, and thank you, Chase, for the question. I think it's interesting. A lot of people don't really realize, but in a year like this, it's coming to almost becoming common knowledge that we are the second most arid state in the nation, and we may be challenging for the most arid with the winter we've just had. So I'd say the universe of opportunities to establish a stream segment as navigable, in fact, is relatively small. In proving that those streams were useful at statehood in 1896 for useful for and commerce is a common term, but a couple of U.S. Supreme Court decisions, including the Daniel Ball, says it needs to be trade and travel, and so I have a little bit of a difference of opinion with Mr. Battle on this. I guess as cordwood floats doesn't mean both trade and travel and commerce. But anyway, proving that in arid Utah would be difficult. Most Utah streams run high for a short period of time during snow melt. Then they run intermittently the rest of the year. So as we're talking about the case on the Provo River, that one is one of those that as you think about the water running out of the Uintas and down through the Provo, obviously winter snow melt and springtime is the high flow of that river. And anything after that, in fact, I've heard that some journals document that the Provo River actually dried up before the Deer Creek Reservoir was built, and then started releasing the flows to keep it relatively uniform. So, if I'm thinking about Utah, the universe is relatively small. And from a recreational standpoint, that probably would be a very important factor of what they would want to look at for navigability.
Okay. Thank you, Randy. And then I have a couple questions from the public that I will just open up to either of you if you want to take them. The first one is the use restrictions mentioned are primarily for recreational use on these non-navigable streams that are within private property. Is there any guidance for utility or stormwater management of these streams, like clearing debris or anything like that on private property that extends into the river channel?
That's a really interesting question. It's one I've wondered about a lot. It's also a related question. It would be, what are the rights of a water right holder to go onto somebody's property and put in a diversion to get their water right? Do you have a right to go onto someone else's property to do that because you hold a water right, and that this is the most, or perhaps it's the only available point of diversion? So the answer to the question, the short answer to the question is no, the Public Waters Access Act does not cover that, prohibit, or allow it, because the way the act is worded, and how it relates to recreational use. So you just have to go back to our basic law of trespass that existed before the Public Waters Access Act. It still exists for other types of use. And it's my I used to represent a lot of these water districts and utilities when I was practicing, and it's it's my understanding that there is an overriding public easement to protect flood against floods, to provide stormwater, etc. Now, if you're going to go beyond just clearing the stream bed and you're going to create a stormwater detention basin on land outside the stream, you've got to get an easement. You've got to acquire the property rights from the landowner in order to do that. But I believe that these water districts and other public agencies have the basic right to enter streams, non-navigable streams, in order to do these kinds of things.
And then we're running close to the end of time. We got one more. Um, and then Randy, maybe you would like to speak to this one. If a property is declared navigable and or if a property is not declared navigable, so it's a non-navigable section of river, and law enforcement will not enforce trespassing because there is a perceived prescriptive easement, but WIA was in place, what should an owner do?
Well, a perceived easement is not a legal representation. In order to get a prescriptive easement, as Mr. Battle has noted, that takes a court decision. If I'm right on that, Cullen,
Yeah.
that to get a prescriptive easement approved, that takes a court order. So just suggesting that there is one without proving, and I think Mr. Battle did a great job talking about the difficulty in proving that, what it would take to do that. Just making that as a just as a observation that there is a prescriptive easement is not legal, and law enforcement would have to enforce trespass in that situation.
Okay. And then this might be a better question for our second webinar, but I'm not sure if either of you are aware. Is there a place to see all of the navigable waters in Utah? Is there like
Yeah.
an inventory of that?
Yeah. The Division of Natural Resources website. Now this includes, and what they have posted includes not just waters that have been adjudicated by a court, but also includes some waters that they claim are navigable and will uh, treat as navigable. Let me give you an example of that. The Jordan River. It's never been adjudicated,
Mhm.
but the state, through the Forestry, Fire, and State Lands Division, has consistently maintained, and most landowners along the river accept the fact that it's a navigable river because, we all know or should know what our history is. And there was a lot of commerce. There was a lot of up and down the river during the statehood era. Uh, and it's interesting, you see this other parts of the country. Most rivers that are regarded as navigable, that are um, treated by both private and public entities as navigable waters, have never been adjudicated because everybody knows they're navigable, and it would be silly to go to court to establish something that already everybody knows. So, you have this sort of it's kind of an awkward situation when you're talking about a river that some people think they know and other people think they know it's not. And that's where law enforcement becomes, and this would be a good one to talk to your law enforcement guys about in your next session. Um, uh, are they supposed to put blinders on and pretend like everything is private and non-navigable? Or if they're aware of facts, history, etc., in their communities that would suggest that yes, these rivers are navigable, they were used as highways of commerce at the time of statehood. And they decide, no, we're not going to cite people for trespass using these rivers just because a landowner wants us to.
If
The law enforcement has to make a judgment about what and how they're going to enforce the laws. And I think that's where you're seeing on the Provo, for example, Wasatch County was not asserting trespass against any of the people that have been using the Provo because they are convinced, as are the folks that are bringing the lawsuit, that the court will find that this river was navigable based upon an extensive history, starting in the 1870s, of log drives on the river that were an essential element of Utah's commerce and development at the time.
Yeah. Well,
Point,
that's very,
maybe a quick point here,
yeah,
Chase, that I think may be relevant too is in a state that's got 65% federally owned lands and another 8% state-owned lands. You're sitting about 75% of the state that is publicly owned, and the rivers that run across those are obviously all open to the public to recreate on at their will.
that's a good point to mention. That's not just navigable, but it's all streams and rivers across public land as well.
Exactly.
Okay, well, with that, we are out of time. Thank you for everybody who's attending. Thank you for our two panelists who have shared their wisdom and knowledge with us. So we're going to conclude the first webinar. If you have any questions, I think Liz posted in the chat that she will read or send those to our panelists to try to get you answers to those if we didn't get to them. And thanks for attending. We hope to see you at the next webinar on May 26th, also at 11 a.m. And if you would like to see more information on those, you can find them at our website. And yeah, thank you again. We hope to see you at the next one. Bye, everyone.
Thanks,
Thank
everybody.
you.
Bye.